Imagine a scenario where a 200-year-old law is suddenly used to tackle modern-day issues, only to face a major legal setback. That's exactly what happened when a federal court ruled against the Trump administration's attempt to deport alleged Venezuelan gang members using an archaic wartime statute. On Tuesday, a panel of the Fifth U.S. Court of Appeals decided to halt the Trump administration's efforts to remove individuals suspected of being part of the Venezuelan gang, Tren de Aragua, under the Alien Enemies Act of 1798. This 18th century law, originally designed to deal with enemy aliens during times of war, was being applied in a way that many found unprecedented and legally questionable. The court's decision came after a 2-to-1 vote, with the majority concluding that the administration's assertion that Tren de Aragua members represent a warlike invasion was unfounded. Our analysis leads us to grant a preliminary injunction to prevent removal because we find no invasion or predatory incursion, the majority wrote. Lee Gallant, an attorney with the American Civil Liberties Union, ACLU, and a key figure in representing the plaintiffs, praised the court's decision. The Trump administration's attempt to use a wartime statute during peacetime to regulate immigration was rightly shut down by the court, Gallant stated. This is a tremendously important victory, reining in the administration's view that it can simply declare an emergency without any oversight by the courts. But here's where it gets controversial. Some argue that the administration's actions were necessary to protect national security, while others see it as an overreach of executive power. The controversy began earlier this year when the State Department designated Tren de Aragua as a foreign terrorist organization. In March, the White House issued a statement claiming the gang was engaging in irregular warfare and undertaking hostile actions against the United States, including mass illegal migration to the country. However, the administration faced another setback in April, when the Supreme Court intervened, halting the planned deportation of alleged Tren de Aragua members being held in Texas. The court ruled that the individuals were not given adequate notice, only 24 hours, under the right to due process. Subsequently, the administration adjusted its procedures to provide 7 days' notice, which the Fifth Circuit deemed sufficient for due process. The Fifth Circuit's ruling specifically addresses the use of the Alien Enemies Act for removal purposes and does not impact other legal avenues for deporting so-called foreign terrorists. And this is the part most people miss. The court's decision is narrowly focused on the application of this particular act, leaving open the possibility for other legal actions. Judge Leslie Southwick, appointed by President George W. Bush, and Judge Irma Ramirez, appointed by President Joe Biden, both supported the preliminary injunction blocking the use of the Alien Enemies Act. Judge Andrew Oldham, a Trump appointee, dissented, arguing that the president's declaration of a predatory incursion is not conclusive and must be backed by sufficient evidence. His declaration of a predatory incursion is not conclusive, far from it. Rather, President Trump must plead sufficient facts, much like a regular plaintiff in a breach of contract case, to convince a federal judge that he is entitled to relief, Oldham stated. What do you think? Is the court's decision a necessary check on executive power? Or does it undermine efforts to protect national security? Share your thoughts in the comments.